Well, hello there, everyone, and welcome to lecture three. Yes, lecture three. And for those of you who are listening to it in advance, I hope you enjoy this. I think it will be a little easier, and I think you'll be starting to get the language now and the feeling of how the carriage picture sort of works. And the bill of lading is one small part of that big picture. So in week one, we looked at the entire picture and we had the time charterer and the owner and a sub charter. And then last week we did the sub charter, the voyage charter, and now we're making it even smaller. Now we're doing the bill of lading and I think the language will become will be by now a little more familiar to you, and I think it will just be getting easier. So fingers crossed, and let's see how we get on. And of course, we're going to meet to talk about all this on Thursday, so that's fine. And what you don't understand today, which hopefully you will, we'll be able to talk about on Thursday. So, lecture three, bills of lading. And you'll see, let me just go back. You'll see here that I've set out that the reading is Chewer, chapter 6. And it's really very nicely set out. So I haven't, for most of the points, set out which particular sections you should read because they've all got in Chewer's book nice side headings. So you should be able to follow the chapter quite easily. I've only on a couple of occasions pointed stuff out where I think you should have particular attention. And excuse me, I always seem to have to cough when I'm recording. The first slide, of course, is a focus on, as you can see, is on a specific part of the chapter, and that's right at the beginning, and that's looking at bills of lading in trade practice. And in actual fact, Chewer's view here is on trade practice from a moving forward, looking forward point of modernity. The issue is with electronic bills of lading. Now, electronic bills of lading have been around a long time, not as long as I've been working in the industry, I think, but certainly a long while. And the main project was the Bolero project, which actually Chewer does talk about quite a bit, I think, in his book. But it wasn't awfully successful. And I think that probably was because of a sort of a reluctance to embrace electronic bills of lading and the difficulties it was thought they would cause. And Bolero project is actually quite self-contained and small, so it's not in use generally. But the world has changed, as the world always does. And we now have the electronic cargo dock system, and things have moved on. And so much so that we even have statutory regulation now, as you'll see from Jason's book. And UNCITRAL, the United Nations Commission for International Trade, that has come up with a model law on electronic transferable records. A model law from one of the United Nations bodies, like there was a model law on arbitration. A model law is where a sensible working frame is developed, which can be translated into law, and that is shared around on the international market. And it is hoped that members of the international market, so different countries, that they will adopt the UNCITRAL model law on a particular issue, because that will create a level playing field, uniformity and consistency of regulation in trade. And to a certain extent it works quite well. The UK is always somewhat reluctant to adopt model laws from UNCITRAL, but I think that's probably a peculiarity of us being on a little island. But they're here. UNCITRAL is here, and so we can't avoid it, and we have to look forward. And the Rotterdam rules, which are a cargo regime we talk about in the final week, the Rotterdam rules are not in force, but they've received a lot of focus. And it probably is the case that they won't come into force. That's certainly what I think. But if they don't, something will replace them. Because I think what is crystal clear now to everyone in the trade, that the two big international regimes, the Hague and Hague-Visby rules, are really somewhat out of date and struggling to cope with multimodal transport and through bills of lading. And really they're just becoming a little outdated. So there will be something, even if it's not, as I don't think it will be, the Rotterdam rules. But the point to take on board is that the Rotterdam rules contain provisions about electronic bills. And so it really is where we're moving to. And Jason is an excellent one to write about where we're moving to. So I very much suggest that you read his sections on this in the book. We need to know whether or not our bill of lading is paper or electronic. We need to know certain key aspects of the bill. We need to know the role of the bill of lading. We need to be able to understand the liabilities for ship owners, to bills of lading holders. And we need to understand about bills of lading issued under time charters, and we need to understand the importance of clean bills. So just to give a slight recap on that, the role of the bill of lading is very important in trade because, long story short, it can act as a contract of carriage which can be on-sold from one consignee to other. And the classic bill of lading, the workhorse bill, perhaps actually it's not true to call it the classic one because the focus on it as an order bill, which is what I'm leading up to, the focus on it as an order bill is probably only since the early 1900s. And trade and bills of lading have been around for longer than that. But we tend to call this document called an order bill because it can be on-sold by one consignee to another as a contract. We tend to call it an order bill because it really has become the big one, the workhorse. So you could say it's the classic bill of lading now. And it not only has a contractual capacity, but it also acts as security for the goods. It stands in the shoes of the goods. And we say that it acts as a document of title. And then we have to see in its contractual capacity, so where the bill of lading is sold to a consignee and it becomes a contract, and we looked at that last week. Today, under the Carriage of Goods by Sea Act in 1992, where it becomes a contract in a chain of charters and sub-charters. The question is, does the ship owner have liability on this bill of lading? And if you go back to the picture we looked at in the first week, you'll see that we've got the owner and the time charter, and then we've got the time charterer and he sub-charters out on a voyage charter, and goods will be shipped and a bill of lading will be issued for those goods. It is highly likely that that bill of lading will be unsold on a CIF basis to a subsequent consignee, and he will take the bill of lading as his contract. And the question will be, well, who is his carrier? Is it an owner's bill? Is it a charterer's bill? And so the owner has to know this, as does the consignee, and we look at that. And then we look at bills of lading that are issued under charters. And if a bill of lading is issued under a time charter, or indeed if it's issued under a voyage charter, I'm not quite sure why I specifically chose time charters there. If a bill of lading is issued under a charter party, do the clauses in the charter party get dragged in on a sort of like a process of osmosis basis into the bill of lading? And that's a very tense issue in the trade. And then we have this concept called a clean bill of lading. And I think someone raised this in one of the reading groups last week. A clean bill of lading is a bill of lading that shows that the goods have been shipped in the condition which they should be. And this actually means that they are shipped according to the requirements of the contract of carriage, what the shipper said about them. And the shipper, of course, if he's sold them CIF, he's got to make sure that what's in the contract of carriage, and so is then mirrored in a clean bill of lading, there's nothing wrong with the goods, actually does then match the requirements of the contract of sale. And what happens if the goods arrive at the port of discharge and the document isn't there? What happens if the bills haven't arrived? What is the impact on the carrier if he delivers the goods without production of the bill of lading? And that's a big issue. And it's a particularly big issue in sectors of the trade, in modern trade today, like the oil trade, particularly the oil trade, where oil is invariably shipped around under a voyage charter. And as we know from last week, when she arrives and she gives a notice of readiness, laytime will start, after which demurrage will kick in. And it may be that the vessel is actually on the berth and the bills aren't there, and she can't release the goods, and so demurrage runs along. And of course, in some ways, that's a good thing for the owner, but in many ways, it's not good for anybody because it sort of pushes rates up. And everybody really wants to get the fixture over within the next fixture on its way. So what is the impact, and are there any ways around the problems of the goods being there before the bills? And then lastly, we should keep in mind something we very much touched on last week, the value of a freight prepaid clause in a bill of lading. And that, of course, takes us back to the matrix of contracts. Right. So the first thing, which is big one, I suppose, is the role of the bills of lading. And the bill of lading has basically three main roles. It acts as a receipt for the goods shipped. It is regarded as a document of title. And I word that quite carefully. I don't put it is a document of title, because in actual fact, the lawful holder of the bill of lading might hold the bill of lading in respect of part of a bulk, unascertained goods, an undefined part of the bulk that is bought from the seller on CIF terms, who of course was the shipper. So the buyer takes the bill of lading, he pays against the bill of lading, the risk of the goods is transferred to him, he is regarded as holding that portion of the goods, that quantity of the goods, but under English law, of course, under the Sale of Goods Act, the property in unascertained goods cannot pass to the buyer. And so it's hard in some ways as a lawyer to say that the document I hold that gives me the right to the goods is a document of title, when in actual fact somebody else has the title in the goods. And that's quite a tricky issue. And the last function is that it has a contractual capacity. It will either evidence the liner shipper's contract with his carrier. So the liner shipper has a bill that is capable of being brought into court to evidence the contract of carriage, which means he has a bill of lading type contract, or where it is unsold to the CIF buyer, it becomes the contract. This is a new consignee. The consignee isn't the shipper. He's a new party to the picture. Then the bill becomes the contract in the new consignee's hands. And so it has two ways in which it has a contractual capacity, either as evidence of the shipper's contract of carriage or as the contract in the subsequent consignee's hands. What is critical at this point to take on board is that it only evidences a liner shipper's contract where the contract is contained in the charter. So in other words, where the shipper voyage charters the vessel to carry the goods, the bill of lading which is issued has no contractual status whatsoever in that chartering shipper's hands. He can onsell it with the CIF sale documents. He can onsell it to his CIF buyer. He can transfer that bill of lading as a brand new contract, or the contract, in the new consignee's hands down here. And so the new consignee has a bill of lading contract, but our chartering shipper does not have a bill of lading contract. The chartering shipper takes the bill of lading as a receipt for the goods. Whilst he still holds it, is regarded as his document of title, but it does not go into court to prove or disprove terms of the contract. It is not evidence of a charter party. And therefore, of course, the chartering shipper does not have a bill of lading type contract. The chartering shipper does not have a contract, which is like a document of title type contract. And therefore, of course, and this takes us back to last week, therefore, of course, the Hague and Hague-Visby rules do not apply by force of law to charter parties, which counts for the importance of the clause paramount. So this contractual role is quite difficult to start with, to get one's head round, but this is how it is. And so we've got the basic outline of bills of lading. And just before we look at those roles in depth, I'm just going to outline the types of bills. The one we are normally concerned with is what we call an order bill. This is the bill that once it is transferred to a new consignee hand, and it becomes the contract of carriage, it can actually be made out then to the order of that consignee. That is what an order bill is. It has either on the top order bill or under the consignee box, it has to the order of the consignee. And that means that the consignee who holds it as a contract against the carrier can cross his name out, put a new consignee's name in, who of course would be a new CIF buyer, buying from our first CIF buyer. So a new consignee's name is inserted to the order of the previous consignee, and its status as a contract is unsold to the new consignee. The new consignee doesn't get a new contract, he gets the contract that the first consignee held, and that's what we mean by a negotiable document. My shares in Boots the Chemist are negotiable documents. That means I can sell my shares, I can sell my relationship with Boots, I can sell it to you. Because I can sell my shares to you, my share certificate is a negotiable document. And that's the big one in international trade. And it's the big one for two reasons. Partly because order bills, as I've just said, allow the consignee to cross his name out, make it to his order, and on-sell the bill, which of course represents the goods, under a new CIF contract to a new CIF buyer. And also, if you have an order bill, only the lawful holder of an order bill is entitled to the goods. And so it really sort of consolidates and gives it, it's a heavyweight bill in international trade. Now, we have other bills, and I say this quite sort of cautiously, because there are what we call Strait and Seaway bills. And some people talk about there being differences between Strait and Seaway bills, and some people regard them as being one and the same. And I'm not sure which camp I fall in. I think, on balance, I'm probably of the view that the two are the one, so to speak. But when we get to our reading group on Thursday, when we get to the reading groups, we'll see, when we look at a case called the Raffaella S., we will see that in actual fact, Lord Stein thought that seaway bills were different from strait bills in one respect. And so who knows is the answer. Who knows? To be honest, who knows? Generally, order bills are used. Strait or seaway bills might be used. And as the issue is what is the carrier's liability, it's always going to be what is the carrier's liability. And actually today, since the Raffaella S., it won't really make a lot of difference. It isn't really a particularly contentious issue. But just be aware of the debate. And then we also have, we don't see many cases on these, we also have something called switch bills. And this is a difficult one. And Chua is excellent on this. And he has a box in section 6037 on page 244. And I suggest you read that. A switch bill is basically what it suggests. It's switched. In other words, what would have been the original bill of lading isn't issued, and a switch bill, a bill in its place, is filled out. And that is because it allows the carrier and the shipper and the consignee to decide after the goods are shipped where the goods may be going to, because the shipper may not have actually designated the port. He may have put one in a safe range, New York, East Coast US, for example. It may be that when the goods are sold, there are difficulties about shipping the goods from a particular jurisdiction. There may be difficulties about shipping the goods from jurisdiction A if they are going to jurisdiction B. And so a bill of lading will be issued later, perhaps in another jurisdiction. So it will be switched, so to speak. And that can be for political reasons. And these are difficult because there's a lack of transparency and clarity. There's often a lack of a proper cohesive thread as where was the bill issued, where the goods are going to be discharged. And in actual fact, the parties are fairly quiet about this, and you don't see much litigation. And I would think it's because parties don't want to focus on what they're doing under a switch bill, and so they don't bring any dispute into the commercial court. So there are very few cases. Anyway, I suggest you read that and think about it and perhaps smile to yourself. I'm not going to say anything else about switch bills. And then we have a fourth document, which isn't a bill of lading at all, and it's actually why I flagged this up here. And that's what we call the ship's delivery order. And that is not a bill. A ship's delivery order is an order by the carrier to the agent in port to release a proportion of the goods against the production of this order from the carrier. And so it's a ship's delivery order. And these are not bills of lading. And the reason they're not bills of lading is because they don't have terms and conditions on them. Now, the reason I'm flagging this up is because under COGSA 92, the Carriage of Goods by Sea Act 1992, in addition to the lawful holder of an order bill being able to sue the carrier, in addition to the holder of a strait or seaway type bill being able to sue the carrier, the lawful holder of a ship's delivery order is able to sue the carrier. Now, if you're holding what we might call the classic bill of lading, the workhorse, the order bill, or you're holding a strait or seaway type bill, those bills all look more or less the same, and they do have the carrier's terms and conditions on the back. And in actual fact, since this case I've mentioned, the Rafaela S., they're all pretty much of a muchness in terms of carriers' liabilities, because the House of Lords agreed with the Court of Appeal in this case that in actual fact they all came under mandatory application of the Hague and Hague-Visby rules. And so they're all much of a muchness. But ship's delivery orders are not caught by mandatory application of the Hague or Hague-Visby rules. They're not document of title type documents. They don't stand in the shoes of the goods. They can't be pledged with a bank for security. And they haven't got terms and conditions on. So if you're the lawful holder of a ship's delivery order, where is your contract? And judicial discussion and academic debate have sort of pointed us back to the bill under which the goods were shipped, which makes sense. That makes sense because the consignee will know from where the goods were shipped, so he knows what carriage regime will apply. The bill of lading will be governed, therefore, by one of the carriage regimes, which makes them all much of a muchness. And the consignee is not going to be caught by unfavourable clauses in an underlying charter party. So it makes good commercial sense. Right, so the first of the functions. Excuse me. Right, the bill of lading is a receipt. And in the hands of the shipper, it is prima facie a receipt for the goods shipped. And this has always been the case, and this is the case today. And so it's admissible in court to show what was shipped, but in actual fact it can be refuted. And the person wanting to refute the statement in the statement in the bill of lading about the goods is the one who has to show that the statement is not true. And generally this will be the carrier, but not always. But it is always the case that it is the person seeking to show that the bill should be refuted, its worth as a receipt should be refuted, who has to prove that what's in the bill is not actually the reality. So now this takes us on to some developments, and this takes us on to a case called Grant and Norway. And I want to talk about this because Chua particularly flags this up. And he, in fact, does deal with this nicely, and so we should look at it. Although Chua says something I'm not sure I actually quite agree with, and you can hear what I say, and then you can go away and think about it for yourselves, and you can see what you think, and you can come back and tell me whether or not you agree with me. And it all starts with this case, Grant and Norway. Sorry, I seem to have developed a cough. I always seem to develop a cough when I'm having to record. It makes me very anxious. The recording makes me anxious, not the coughing. So Grant and Norway, right. Well, in this case, a bill of lading was issued which said that some bales of silk had been shipped. And the bill of lading was transferred to the consignee. And the consignee took the bill of lading and said, but there isn't this silk on board the vessel. And he wanted to bring a claim against the carrier. Now, the carrier was able to show that what was in the bill wasn't actually reality. And the carrier said that he had no liability because the master should never have signed the bill of lading on such a misrepresented basis, and that he had no authority to do this. He had no authority to bring this as a liability between the ship owner and the consignee on the principles of agency. And so the consignee's claim failed against the carrier. Now, we should just take a step back to reflect on this. Firstly, the date of the case, it's 1851. So that's in quite a different sort of culture. And one would think, well, given that bills of lading have such a worth in trade, they stand in the shoes of the goods, they represent the ability to onsell a contract of carriage, which means if you are a CIF buyer, you can onsell the goods CIF whilst they are afloat. But your buyer doesn't want to take a bill which he can't trust, and this has a very, very detrimental effect on modern trade. And so the question is, what is the impact of Grant and Norway on the worth of the bill? And it's a negative one. And times were changing, and it was thought that this was not really encouraged the right way to go. And just after Grant and Norway, note the date, 1851, so this was not a case where the consignee sued the carrier under the Bills of Lading Act, because the Bills of Lading Act didn't exist at the time. He would have brought a claim against the carrier under the implied contract theory, on which the Bills of Lading Act was based. And to mitigate the harshness of Grant and Norway, Section 3 of the Bills of Lading Act 1855 says that the bill of lading actually is conclusive evidence of the contract of carriage. Sorry, it is conclusive. It is a conclusive receipt in the hands of the consignee, not the shipper. It doesn't mention the shipper. It is conclusive evidence in the hands of the shipper, except where the carrier can show that there was fraud by the shipper with no fault on the behalf of the master. Then the carrier has this defence. Well, I've got two things to say about this. Firstly, there still isn't a very good impact on trade, because whilst we may say, well, we don't want the carrier to be liable for fraud on the part of the shipper, it's his relationship with the shipper. If it transpires that this happened, he should bring a claim for an indemnity against the shipper. And if his shipper has disappeared, done a runner, so to speak, well, unfortunately, he fixed with not a good trading party. And that's generally the dynamic of commercial law. And that's generally how the trade sees things. So it's rather, you make a choice, you pay your price when you're contracting with someone. And it's really hard, it's still really hard on the consignee, because he might have bought it down the line in a chain, And he's bought the bill of lading in good faith. He thinks it firmly represents the goods. He's bought those goods, CIF, and all of a sudden he finds that the bill of lading actually isn't a proper representation of what was shipped. So it's still bad news. It's still bad news for the worth of the bill of lading, its integrity and trade. So I think this is actually unsatisfactory. The other thing I find strange, and this is the bit you should read, is that Chua talks about Section 3 as creating an estoppel. Now, in actual fact, although Chua seems to suggest that Section 3 says that there is an estoppel, it doesn't. It doesn't use the word estoppel. And I would think it doesn't use the word estoppel for perhaps two reasons. Firstly, it is unlikely, back in the day in 1855, that Parliament would have introduced the estoppel into a commercial statutory provision. Estoppel, apart from proprietary estoppel, is, of course, the creation of equity. And the commercial courts don't really like equity because they feel it's a bit too whiffy-waffy and uncertain. And so it's unlikely that Parliament would have made this into an estoppel, and it would have to be an equitable estoppel. But it also strikes me as unlikely because the Bills of Lading Act is 1855, and really the equitable estoppel didn't properly emerge until Denning in High Tree's case, which was 1940-something. So I'm actually not thinking on the same lines as Jason, and you read what he says and read Section 3 of the Bills of Lading Act, download it and have a look at it to see what you think. And the reason I point this out, it certainly is not to criticise Jason. Jason is an excellent writer and an excellent lawyer and an excellent academic. But this, of course, is his take, his perception. And what we should always keep in mind is that there's generally a reason for somebody's perception. We just have to find our way there. So I'm thinking about this. So it's opened my mind to the thought of some debate on this. But also we must always keep in mind that Chua, Bourne, they are secondary sources of law. They're not the law. It's their subjective assessment of the law. And so be careful. The law is not in the textbooks. The law is in the cases and the statutory provisions. Anyway, perhaps we could discuss that on Thursday. Right. Anyway, all this is somewhat academic because the picture has changed. And there's a much more modern expectation approach now. In the Visby amendments to the Hague Rules in 1968, which led to the Hague-Visby Rules, Article 3, Rule 3 says that in the hands of the consignee, the bill of lading is conclusive evidence of what it says. And that then was reflected also in the Hamburg Rules. Now, this isn't in the Hague Rules, and so if you were the lawful holder of a bill of lading under the Hague Rules, you were a bit out of the cold on this one. But in actual fact, that also has been remedied. Section 4 of the Carriage of Goods by Sea Act 1992. This is the act, of course, which makes the lawful holder of the bill of lading in a contract with the carrier. Section 4 says that that lawful holder holds that bill as conclusive evidence against the carrier. So, to my mind, we know exactly where we should be. Now, as I've said, clean bills of lading are a critical feature because when you are a CIF seller, you need to A, ship conforming goods, the first tier, and B, you need to tender conforming documents. That bill of lading must, as far as the bill of lading can do, and in modern trade with containers and pallets, particularly with containers because the container trade is enormous, that can be difficult. And the reality in modern trading is that the bill of lading will often say, shipper says, shipper's assertion. So the carrier is not making a steadfast assertion. But in the bulk cargo trade, it is more likely that the master will be more forthcoming. Now, he must issue a clean bill of lading in order to satisfy his shipper, because his shipper will be a CIF buyer, his shipper will be a CIF seller who, of course, has to tender conforming documents. What if the goods are not conforming? The carrier will get enormous pressure to issue a clean bill of lading, even though he would rather issue a claused one. If he issues a clause bill of lading, he is safe from the consignee suing him because the goods are not in the condition the bill of lading suggests. But the problem is that's going to put his shipper under pressure, and the shipper will undoubtedly put pressure on him to put a gloss on the bill of lading. And this is what leads to our thoughts of fraudulent bills of lading. Bills of lading that are clean when they shouldn't be, bills of lading that have the wrong date on, have been said to be the cancer of international trade. And the clean bills of lading issue is very, very tense. So the rule is if the carrier is unhappy that the goods are in accordance with the contract of carriage, which of course then has to be in accordance with the contract of sale. So our seller has to make sure that the goods are detailed in the contract of sale, and then he has to have these goods detailed in the contract of carriage because the bill of lading has to match the requirements of the contract of carriage. If the goods don't match the requirements when they're actually shipped, our carrier should clause them. P&I advice would be to clause the bill of lading. Now, we've already talked about when the carrier will get pressure not to do so. But the carrier must be careful. He must look at the contract of carriage carefully, because if the contract of carriage, the underlying carriage, shows the faults in the goods, then there's nothing to clause, because that's what the contract of carriage is about. And many, many damaged goods are shipped having been sold in that state. So the carrier has to be careful here. So that is where we are with that. Now, moving on. The bill of lading as a document of title. We should be careful. We should be careful because when we as black letter lawyers, in other words, lawyers looking at just the law, no policy, when we talk about documents of title, we generally mean, and we certainly do if we are in banking or land law, property law, we generally mean a document that absolutely represents the person who holds the documents actually is the owner of the goods. And we might go even further and say in some circumstances the actual document itself contains the title to the property. Now, in actual fact, this is sort of how it arose back in the day when trade was back in the day. Because the goods would be loaded, a bill of lading would be issued, the bill of lading would be given to the buyer, he would take the bill of lading whilst at the same time handing the bag of gold coins to the seller. As we know in modern language, under the Sale of Goods Act, the property in the goods is expected to pass in return for payment. And so it became in trade's mind synonymous. The passing of the bill of lading sort of triggered the moving of the property. Passing of the bill of lading would move the property. But in actual fact, it's not that. In actual fact, what moves the property is the intention of the parties and the payment of the goods, except where the goods are unascertained. So it's actually in modern terms that document of title is not really quite appropriate, because in modern terms where we have the bulk cargo carriers and portions of bulk are sold to different buyers on CIF terms, and those different buyers each buy a bill of lading and they pay against the bill of lading. They don't actually take the property in the goods, because under English law, Section 16 of the Sale of Goods Act provides that the property in unascertained goods cannot pass to the buyer. The bill of lading can be transferred. The buyer buys the bill of lading and pays against it. He takes the risk of loss and damage by a third party under the contract of sale. He holds this bill of lading. If it's an order bill, it must be presented in order for collection of the goods. So he's the lawful holder of an order bill, but he doesn't own the goods. But he's the lawful holder of the bill. He's the only person entitled to discharge of the goods set out in that bill. And so really we could say that the bill stands in the shoes of the goods. He who holds the bill is exactly the same as actually holding the goods. And the bill of lading's function in this purpose, and we can call it a document of title, The bill of lading's function in this purpose as a document that stands in the shoes of the goods, acts as a document of title, is critical because, of course, it can be pledged for finance with a bank. Now, in terms of it being a document of title, that it is the key to the warehouse, it stands in the shoes of the goods, this passing of property is not a critical problem now, but it was, because the bill of lading being transferred as a contract used to be triggered by the Bills of Lading Act 1855, which required the bill of lading and the transfer of the property in the goods. So the CIF seller had to transfer the property in the goods, which would generally happen upon payment, and the bill of lading at the same time. The trouble is, under the Sale of Goods Act, the property in unascertained goods cannot pass. So our buyer would hold a bill of lading, he would have paid for the bill of lading, he would have taken the risk of loss and damage to the goods, but he couldn't sue the carrier. And this became a problem, and it became apparent that the Bills of Lading Act 1855 was out of date, and eventually Parliament changed the law, repealed the 1855 Act, and brought contracts against carriers into modernity, and enacted the Carriage of Goods by Sea Act 1992. Now, in actual fact, we saw this problem in a negligence case called the Ali Akman, and you should go back in your minds to this case. Section 19 of the Sale of Goods Act says that the seller can reserve the title in the goods. So the seller can do this. And generally he will do this to protect himself where the buyer just can't pay or may not pay for a while. And this happened in the Ali Akman. Consignment of steel coils were sold C&F. The goods were shipped, clean bill of lading issued. Seller presented the bill of lading to the buyer, who then couldn't pay. He couldn't pay and he couldn't raise any money. So the seller said, okay, well, I really feel your pain, and this is all because the market rate has dropped, and I'll tell you what, let's just carry on as normal. You hold the bill of lading, and when you can sell the goods, you can on-sell them, and then you can pay me when you've got the money. But just to cover my back in case you go into liquidation, I will note on the bill of lading that I have reserved the title in the goods. They are still my goods until you pay for them. Steel goods were discharged. The carrier had caused loss and damage to them by not packing and carrying them properly. Also, the consignee wants to bring a claim against the carrier. The consignee can't bring a claim against the carrier under the Bills of Lading Act because the Bills of Lading Act require you to have the bill of lading and the property in the goods, which, dint of Section 19, our buyer in the Ali Akman doesn't have. So he sued the carrier in negligence. Now, in actual fact, you may remember that the claim failed because the House of Lords said no duty of care owed for pure economic loss because, of course, our claimant didn't own the goods, the seller owned the goods. So actually he's suing for loss and damage in respect of goods that are not his, pure economic loss. Now this case came up to the House of Lords about 4 years after Junior Books, in which the House of Lords had sort of blipped and allowed a claim for pure economic loss. And that's probably what drove the Ali Akman up to the House of Lords. And it's probably why the case was given leave to appeal from the Court of Appeal to the House of Lords, because there was a lot of dissatisfaction with the Ali Akman on this point in the Court of Appeal. Lord Brandon had given a very firm dissenting speech in the Ali Akman, saying, well, guys, this really isn't the way to go. It will open the floodgates of litigation. We should stick with the policy concerns that negligence has about pure economic loss and not recognise a duty. But of course, that's not the way Junior Books went. But Lord Brandon was on the panel again in the Ali Akman not 4 years later. And it's quite clear from the tenor of his speech that he really saw it as an opportunity to bring negligence back where it belonged, bring it back into the fold, so to speak. Now, the other strand to his speech is usually missed by undergraduates doing tort, but it absolutely relates to us here because it makes us think forward. Lord Brandon said it wouldn't be a good idea anyway for this consignee to sue the carrier in negligence, because if he sues the carrier in negligence because he has no contract with him, the carrier cannot limit his liability under the Hague or Hague-Visby rules. And this is a critical issue. And so once again, we see limitation as king, and once again, we see the matrix coming into play. And actually, the Grain and Feed Trade Association put a lot of pressure on the government, GAFTA, Grain and Feed Trade Association. They put a lot of pressure on the government and said, if you don't change the law, we're actually going to move GAFTA litigation and arbitration out of England, away from the English Commercial Court. So Parliament sort of stepped up to the plate and repealed the Bills of Lading Act and remedied the problem by enacting under the Carriage of Goods by Sea Act that all you have to be now is the lawful holder of the Bill of Lading. The Law Commission, in their report for COGS in 92, actually do spend a bit of time considering the Alley Actman and saying part of the drive is to stop this problem that occurred in the Alley Actman. So that is the Bill of Lading as a document of title. We regard it as a document of title. It stands in the shoes of the goods, even if, in actual fact, in black letter sales law, the buyer, the consignee, does not actually have the title in the goods. And the Bill of Lading as a document of title cannot be underestimated. Stands in the shoes of the goods. It acts as the key to the warehouse. And it acts as security for goods, so it can be used, it can be pledged with a bank to raise finance against international sales. And it's a big one. It's an absolutely big issue. And usually, these days, bills of lading are used to support a letter of credit. And we have to remember that when we're lawyers, we do use language sometimes sort of interchangeably. We can think now, since the Raffaella-S, we can think from Lord Stein that, and we will look at this in the reading group, because the Raffaella-S is your case to read for Thursday's reading groups. Lord Stein said that Lord Stein's speech leads us to speculate that a document of title in one respect may not be considered to be a document of title in another. And Lord Stein speculated and discussed that a document of title for the purpose of standing in the shoes of the goods for security, for raising finance on letters of credit, might actually not be the same as being a document of title for the purposes of mandatory application of the Hague or Hague-Visby rules. And we will look at that, but it's worth flagging up now. So that is the importance of the Bill of Lading as a document of title. And now we come on to the Bill of Lading as a contract, its contractual functions. So as I said earlier, it's evidence of the contract in the non-chartering shipper's hands. And above the water level of the iceberg, when we lawyers talk about something being evidence of a contract, what we mean is it is admissible into court to prove or disprove what is said about the contract. And that's exactly what happened here in the Ardennes. The shipper contracted with the carrier for the carriage of a consignment of oranges from Spain to London. And he impressed upon the carrier that this was an early shipment. It was before the market was flooded with oranges, and therefore when the market price was high. And he impressed this upon the carrier, and they agreed that the carrier would not deviate. A clean bill of lading was issued. It was transferred to the shipper, who was the claimant because he was also the receiver of the goods. That bill of lading contained the carrier's standard deviation clause, which was a well-drafted, normal, effective clause. Surprise, surprise, the carrier deviated. Surprise, surprise, the goods arrived and had missed the height, they'd missed the very beginning of the market. So by the time the oranges arrived, lots of oranges were here and the market price was falling. The shipper, the cargo interest, brought a claim against the carrier and said, you agreed not to deviate, and I put you on express notice of my special loss and damage, and I'm claiming those damages from you. And the carrier said, oh dear, hold my hands, feel the love, I feel your pain, but actually look, in my bill of lading, which is admissible, which evidences our contract, there is my standard deviation clause, which excludes my liability for the deviation. No, it doesn't, said Lord Goddard. It absolutely doesn't. The fixture, the contract, is formed before the goods are shipped, before the bill of lading is issued. The bill of lading is issued afterwards. It may be, said Lord Goddard, the only evidence. It may be the best evidence you've got of the contract, but evidence only it is. And the shipper had other evidence to show this is what the carrier had said, what they had agreed. And so the bill of lading as evidence of the contract actually was not strong evidence here. We do not, said Lord Goddard, take this mutual exchange of promises and say that the bill of lading is then transposed into the contract, that the promises are transposed into the bill of lading, which becomes the contract. We do not, as some continental jurisdictions do, we do not do that in English law. And it rather goes to a case that you will remember, the chap who approached the car park case, Thornton and Shoe Lane parking. He put his money in the barrier or whatever he went in, and there was an exclusion of liability notice. But too late, said Lord Denning, too late. And Lord Denning, in the Court of Appeal, said the question to ask in every contract is, when is the contract formed? When did that mutual exchange of promises occur? Anything issued afterwards is just too late. Now, if the bill of lading is transferred to a third party, a consignee, as it was in Leddock and Ward, well, then now the new consignee, remember I said the contract is in the document. Parole extrinsic evidence rule applies, nothing else counts. And therefore, the new consignee buys that bill of lading as his contract. In the Ardennes, had the shipper sold the bill of lading to a new consignee as a CIF buyer, that consignee would have bought it with that exclusion clause in for deviation, and the carrier would have had no liability. So this is a very important thing. And so we go back, just to recap, that in the hands of the chartering shipper, this is not the case. The bill of lading has no contractual status whatsoever. And now we've been through this. The bill of lading is transferred to our CIF buyer, and it sort of like pops up as a magic mushroom. And the authority for that today is the Carriage of Goods by Sea Act 1992, which has, one might say, divorced the marriage created by the Bills of Lading Act between holding the property in the goods, the bill of lading, and right of suit. That marriage has been divorced. Today, under the Carriage of Goods by Sea Act 1992, all the consignee has to be is the lawful holder of a bill of lading, or a lawful holder of a straight seaway type bill, or the lawful holder of a ship's delivery order in order to have right of suit in contract against the carrier. And this was the development of that, as we've talked about. Just remember what I said last week. The bill is now a contract. A contract. In other words, a quid pro quo, mutual exchange of promises. So what are the consignee's obligations? As I said before, to pay general average and to pay freight. Right. This is why, of course, the bill of lading in the CIF sale as a freight prepaid bill will be very important. It is a canny buyer who decides that he's going to put his seller on notice that the bill of lading must be a freight prepaid one. And so this is how the matrix is still coming together. How do we know that our consignee's obligations are to pay any outstanding freight, unless, of course, there is a freight prepaid bill, any outstanding freight and general average? How do we know that? Well, we don't get that from the Carriage of Goods by Sea Act, and we didn't get it from the Bills of Lading Act. We get it from case law. This is a judicially developed way of thinking. So we get it from case law. And case law absolutely tells us that there's only two, and I'm going to use this word later, two obligations which are said to be germane to a contract of carriage. And those two obligations are freight, it's essential, it's freight is sacrosanct, and also this concept we call general average, which is a divvying out amongst anyone whose cargo has been saved by the sacrifice of somebody else's cargo, a divvying amongst all of them, an assessment made on a general average basis, so that those whose cargo has been saved by the jettisoning, the sacrificing of somebody else's cargo, all contribute to the loss of the person who has had his cargo sacrificed. That is general average. And the order bill is a negotiable contract. Critical, as I've said, the lawful holder can on-sell it as a contract. So he can on-sell the goods represented by the bill of lading. He can on-sell them CIF. The risk in the goods passes to his new buyer. He, the first buyer who's now on-sold the goods, drops out of the picture, and our new buyer, new consignee, takes that bill of lading as his contract, quid pro quo against the carrier. So it keeps trade going, it keeps it moving. And here I've talked about the aliakman, and here I've talked about the consignee's liabilities. Freight prepaid bill is important. The consignee has, at common law, the obligation to pay outstanding freight and general average. Why is it critical that our consignee has a contract against the carrier rather than pursuing negligence or bailment? Because, of course, if he sues in negligence or bailment because there is no contract, he can't, in carriage terms, limit his liability. Lord Brandon, the aliakman. Who is the consignee's carrier? This is important. You may have a chain of charters, and you may have a head owner and a time charterer, and then you may have a series of subsequent charters. And then eventually the goods are loaded under some subsequent charter, and a bill of lading is issued. And the bill of lading is sold to the consignee. Coxa 92, it is his contract. It's all very well knowing that you have a contract, but given that your contract is highly likely to be regulated by the Hague or Hague-Visby rules, this means you, the consignee, only have a year in which to bring a claim against your carrier. So no shilly-shally, no dilly-dollying around. You've got to find your carrier quickly. And so you have to look at the bill to see for whom did the master sign the bill of lading. Did he sign it on behalf of the owner, in which case the owner is your carrier, or did he sign it on behalf of the time charterer, in which case your time charterer is your carrier. And if you go back to the picture we looked at in week 1, you'll see that I asked these questions in that big picture. Now, it used to be that the consignee had to look at both sides of the bill, and he had to look through the small print to see if there was any reference in the small print about the owner being the carrier, when in actual fact a time charterer's stamp had been put in the front. House of Lords in the Stars Inn said this is no longer the way to go. And this has caused quite some controversy, because a lot of people don't agree with this, but be it what it is what it is. House of Lords, the Stars Inn said, the consignee's carrier is the person for whom the master signs the front of the bill of lading. The consignee should not have to go rooting round to see if someone else is the carrier. And that is a very important case. Right, coming along nicely now. 2 little things to notice here. The bill of lading can be endorsed, an order bill can be endorsed and on-sold as a negotiable document, as a negotiable contract to a subsequent consignee, and so on and so on. And in actual fact, it can come round back to the original shipper, the original CIF seller. It can be sold back to him. So he now is the lawful holder of the bill of lading, and once again, he's got the goods, so to speak. He doesn't buy that bill of lading back as a contract. The bill of lading pops up, cogs and tutu, like a magic mushroom, when it reaches the first consignee who could not fix his own contract, based right back on the concept of the implied contract. It can be sold from consignee 1 to consignee 2 to consignee 3, etc., etc. If it goes right back to the original seller, the original shipper, that is what the commodities trade calls a string or a circle contract. It's in a string, it goes back in a circle to the original seller. Be warned, the moment it goes back to the original seller is the moment its contractual worth in the chain dies. the original shipper buys it back as he held it. And the shipper, this is exactly what happened to the shipper in President of India and Metcalfe. He sold the goods, endorsed the bill of lading, and on it went. The bill of lading went on and eventually came back to him. Now, the bill of lading did not have clauses from the charter party that by now our shipper didn't want, namely, I think, an arbitration clause. And the shipper said, "Oh, look, but I've bought this now. I've bought this bill of lading back. It's a contract." "No, it's not," said Lord Denning. "It absolutely isn't. It was only a contract in its own right whilst it was held at the time Bills of Lading Act, today Cogs 92, whilst it was held by the lawful holder as a self-contained contract. No, it's not a contract now. It has no, you hold it as you always did. You chartered the vessel to carry the goods. The bill of lading has no contractual status in your hand. You cannot buy it. You cannot buy it as a contract because you've got your contract already. So unfortunately, you are stuck with the arbitration clause. Now, it is common for owners to want arbitration clauses and jurisdiction clause in charter parties, to want those reflected in bills of lading. So when the bill of lading is unsold and it becomes a contract, and it's probably a contract against the owner says, "Well, I want those clauses that I had, say, in the time charter, say under the voyage charter. I want those clauses in my bill of lading contract." Now, the House of Lords has looked at this in the mirror and said, no. Only those clauses which are germane to a bill of lading contract can be dragged in by a general clause. Because the fashion was, and it's quite normal actually in contracts under English law, it's quite normal for a contract to say, "and all terms as per." So if you go and buy a railway ticket, not that we're going anywhere at the moment, but if you go and buy a railway ticket and you look on the back, you'll see all terms as per the carriers. That's an all terms clause. Now, in the Mirror, the goods arrived under a voyage charter. The vessel went on to lay time. She exceeded the lay time, and demurrage ran up. And our carrier said, "Oh, quid pro quo, you've got a contract. And that means that all the terms in the bill of lading are actually binding upon you. And one of these terms is all terms as per charter party. And lo and behold, one of the terms of the charter party, surprise, 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 is demurrage. The vessel is on demurrage, and therefore, under the bill of lading contract, under this all terms as per charter party clause, we can claim outstanding demurrage." "No, you can't," said Lord Diplock. "Absolutely not." And he has this wonderful speech where he goes, "No sensible businessman who had not taken leave of his senses would buy a bill in this way and expose himself to such unknown liabilities." Now, of course, you could argue, well, actually, it wasn't an unknown liability. You buy a bill of lading in respect of goods which have been shipped on a charter party. The one thing you will jolly well know is that that charter party is not unlikely to run into difficulties and run up to demurrage. But of course, if you've bought the goods CIS, and of course you've paid for the goods, you would be irritated enough to find that you had outstanding freight to pay. How much more irritated would you be to find out that you'd got that you'd got demurrage? And the House of Lords sort of nipped this in the bud in the Mirror and said, no, that all terms as per charter party clause means nothing. It cannot drag in a demurrage clause. It cannot drag in a jurisdiction clause. It cannot drag in an arbitration clause. If those clauses are to be in the bill of lading, they must be in the bill of lading. Now, you would think this is out of step with the normal approach to the interpretation of all clauses clause in a written contract, because actually it is. Generally, English law is very lax and easygoing about this, but this has big implications in shipping. And Lord Justice Bingham, as he was then, commented on this. He commented on the Mirror with approval and said that in the shipping cases, the courts should be cautious. They should be very, very cautious about how they interpret an all terms clause, and they should be very cautious about bringing in liabilities that just are not going to work out. And so that is the Mirror. Now, we are coming on to the last two slides. And now we've got the goods arrive at the port of discharge. And you've got your goods shipped under an order bill, normally. And that means that the bill must be produced in order for the goods to be collected. And this is a very dangerous issue for the carrier, because frequently, with modern carriers getting there from A to B quickly, frequently the goods will arrive at the port before the documents. And so it's not unusual to have the situation where you've got a consignee who wants his goods and he hasn't yet got the key to the warehouse. Well, can you nip in through the window and open the door from the back, so to speak? Well, the answer, if you were to answer this question in one word, it would have to be no. No. It is very, very, very dangerous for a carrier to deliver the goods without production of the bill of lading, because if he does and it goes wrong, for instance, he delivers the goods to a fraudster, he delivers the goods to the wrong person, he is liable, strictly liable, in the tort of conversion. So that is a big problem. And it's a particular problem in some trades, especially the oil trade, where frequently the vessel carrying the oil will have been voyage chartered. She will arrive at the berth, lay time will run, everybody's ready to go to discharge the goods, and the documents haven't arrived. Now, the oil trade is, like the LNG trades, different from the rest of the trade in this respect, because generally vessels arrive at the port of discharge and they discharge the goods into the port facilities. And these are bailed under the constructive possession of the carrier. So it's like the carrier has still got them. This doesn't happen in the oil trade. In the oil trade, in the LNG trade, the goods arrive at the consignee's terminal facilities and they're discharged into the consignee's facilities. So in actual fact, it doesn't very often go wrong. It's not very often that the vessel will arrive at the wrong facilities. It could be because the goods have been on-sold without the carrier knowing, but it's not very often. And so the vessel is sitting there, she's been voyage chartered, and it's in everybody's interest really to get that vessel through the discharge and off the berth before lay time has kicked in, or before much lay time, before demurrage has kicked in, or before much demurrage has kicked in. And of course the shipper, who has of course sold the goods to the receiver, the chartering shipper under this voyage charter, is especially keen to get these goods off the vessel and into the consignee's facilities, because he's the one paying demurrage. Now, it is recognised that this happens. It is recognised that this happens, and in actual fact, there was a very nice discussion by the judge, in this case called the Segona, where the master said, well, in the circumstances, it couldn't be conversion, and actually, this is normal practice in the oil trade. We were promised an indemnity, and this is normal practice. This is part and parcel of fixing an oil moving charter party. And the judge said, well, I accept that. I accept that it is normal. I accept that most masters may not have seen bills of lading. And I taught a master mariner some years ago who worked in the tanker trade, and we talked about this issue, and he said, I've never seen a bill of lading. And he was a master mariner. And English law tries to take a pragmatic approach here and tries to keep things, commercially viable, but be careful. Be careful, because the carrier can suddenly find commercial pragmatism sort of goes out of the window and he's liable. And if it's oil, he's going to be liable for a huge amount of money. Now, as a final slide then, we can say, is there anything the carrier can do? Well, he can ask the shipper for a letter of indemnity. Now, this is a much, 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 much misunderstood topic. And if there was any one basic message that you've given the trade, it's don't do this. Don't do this without advice, because the chances of it going wrong are phenomenal. And the person who's going to be out in the cold actually will be the carrier, because if he's got release goods against a letter of indemnity that doesn't work out for whatever reason, as we will see, and he's released the goods to the wrong consignee, and the right consignee with the lawful holder of the bill of lading with the key to the warehouse turns up, carrier is going to be strictly liable in conversion. And if that letter of indemnity is not paid against, it's the carrier's liability. He's going to bring this out of his own insurance, and it's likely his P&I club won't cover this because he's released goods outside. It could be that he's released goods outside his cover because he's not allowed to do this. So actually, he's in big bad financial news. Now, the way to do it is to set up a proper letter of indemnity allowance in the contract under which the goods are to be discharged. So this is a two-step process. In order for the promise of the indemnity to be enforceable, it must be a binding promise. In other words, it must have been given for consideration. Never forget your basics in contract. And so the original contract, the charter party under which the goods were shipped, should have goods may be released without bill of lading in return for a valid letter of indemnity. That means that when the letter of indemnity is offered, the release of the goods is the lawful consideration given for the promise of the indemnity. It is lawful because it is allowed within the contract. If this allowance is not in the contract, then it doesn't matter how good the intentions of the shipper are. It doesn't matter how trusting the carrier is. Actually, that letter of indemnity won't be enforceable because it's being given in return for the one thing that the carrier shouldn't do, a breach of contract. He's breaching the contract because he's releasing the goods without the bill of lading. So, first step, there must be a recognition, an allowance, a clause providing for this in the charter party under which the goods were shipped. Secondly, it must be a P&I recognised letter of indemnity form. It must be. If you do not, as the carrier, accept a letter of indemnity form, if you accept a letter of indemnity under any other form, you may find you're without your cover for the whole adventure. So it must be a P&I recognised letter of indemnity form. At this point, if the letter of indemnity provision is in the contract, if an appropriate letter of indemnity P&I club form is used, then the indemnity promise is enforceable. But the carrier still will have a hurdle. What most people don't seem to realise, even in the trade, most people don't seem to realise this, P&I will not pay up against letters of indemnity. Even when they're enforceable, P&I won't pay up against them. So your enforceable, bona fide letter of indemnity, in reality, will only be as good as the depth of the pocket of the shipper, the person who gave it. And that is a very salutary story. It's a very, very robust world out there in shipping, and it's a very salutary story. And so I think the basic message for a lot of these situations is don't fix quickly. Get legal advice over what your next step is doing, because it can save so many tears and so much money later. And that is it, ladies and gentlemen. And I hope you've enjoyed it. It's certainly a topic I enjoy. In the reading groups, we're going to do the Rafaela S. I've asked you to read Lord Justice Rix's judgment, just Lord Justice Rix's judgment in the Court of Appeal. I think it's one of the best considerations of the development of bills of lading around. I think it's absolutely excellent. And the role of bill of lading and how we see it and what we think of as an order bill these days, it's absolutely excellent. And how other hybrid bills have come onto the market. And you should also read the House of Lords speeches, particularly Stein and Rix. I think they're the only ones actually who give developed speeches. But you should read those, not Rix, Bingham, Lord Bingham. So that's for the Thursday reading groups. And that is it. And I look forward to seeing you on Thursday. And please do put your cameras on. Okay, bye-bye.